Jai Hind, Jai Bharat. Today we discuss a very important topic which has been plaguing not only our city of Mumbai but has been equally plaguing a number of places and cities all over India, and even villages in the rural area and the rural police stations are not affected. The disease has become endemic, and we tried to take this matter to the Supreme Court, and we presented a very sordid picture about the menace of fake cases. Yes, I mean the menace of fake criminal cases and fake FIRs that are being registered all over the country day in and day out. I'm not saying all cases are fake, but I said substantial number of cases have been detected to be fake. And when we took this matter before the Supreme Court and we presented the number of problems that are associated with the registration and the aftermath of the fake cases, the Supreme Court, however, said that each and every individual can take up this matter at its own level and even pursue those remedies which were suggested in our writ petition. Our writ petition, filed by me as the founder of Nitya Law Society, was disposed of with that particular order, and Honorable Justice Indira Banerjee and Honorable Justice Himanshu Roy even told us that at our NGO level we can take up this issue with various forums. The writ petition was therefore decided on 5th March 2021. The writ petition was made after my assiduous study for almost 20 years on this issue. The issue is fake FIRs, fake counterblast FIRs, and fake cases. I am myself a victim of 2 or 3 of them. But even before that, I have been seeing people coming to me crying with cases which are patently and on the prima facie face of it fake. Now, how are these cases registered? Why should they be registered? And what are the remedies that even if such a case is registered, what can be done by the common man if a fake FIR is registered against him? This is what we would be discussing today. An FIR is basically a complaint of a cognizable nature. A complaint can be divided into cognizable, in which the police can arrest, and which is seemingly of a more serious nature, and that which is non-cognizable, in which the police cannot arrest but can only take some kind of preventive measure. A cognizable FIR is registered under section 154 of the Code of Criminal Procedure, and a non-cognizable complaint, which is known as the NC complaint, is registered under 155 of the Code of Criminal Procedure. The problem of fake cases, genuine cases, and various kind of problems were taken up by 2 very good judgments which were passed in this topic in the last 10 years. The first judgment on the issue of registration of FIR, on the issue of an order which is known as an order by the magistrate under section 156(3) of the Code of Criminal Procedure. The format of the complaint was first given by 3 judges of the Bombay High Court in the case of Panchambai Popatlal Bhutani versus State of Maharashtra, decided on 10th December 2009 by Honorable Chief Justice Swatantra Kumar, Honorable Justice Roshan Dalvi, and Honorable Justice A.M. Khanwilkar of the Bombay High Court. The judgment is on the aspects of how a complaint is there, how a complaint is to be drafted, whether a complaint has any format. The Code of Criminal Procedure does not prescribe any format of a complaint. A complaint can be a formal complaint. A complaint need not have a particular format. A complaint must identify the complainant, the incident, and a prayer and an application that an FIR must be registered. That is the format of the complaint prescribed under section 2 of the Code of Criminal Procedure. Now, soon after this judgment was made out, a very ubiquitous writ petition on the aspect of whether a police officer is supposed to register an FIR or no was taken up by the Supreme Court of India in Writ Petition Criminal 68 of 2008, which came to be decided by 5 judges of the Supreme Court on 12th of November 2013. The case is a very famously known case known as Lalitha Kumari versus State of UP, headed by Honorable Justice Sathasivam, Honorable Justice B.S. Chauhan, Honorable Justice Bobde, Honorable Justice Ranjan Gokoi, and Honorable Justice Ranjana Prakash Desai. 5 judges of the Supreme Court decided on this issue as to whether an FIR should be registered or not. After this order of Lalitha Kumari has come in, I have seen a phenomenal rise in the registration of fake cases. The order of the Supreme Court was to do and serve justice amongst the citizens. But unfortunately, that order has been misused in a number of cases, and more injustice is being percolating to the citizens of our country rather than the justice prevalent in that particular section. People press for Lalitha Kumari's judgment and even get fake FIRs registered. And as it is, there was an issue of fake FIRs. Now with this aspect of the Supreme Court deciding on a 5-bench judgment, which is 5-member bench of the Supreme Court deciding on it, makes it a constitutionally binding judgment under Article 141. However, the judgment is not a straitjacket formula. The judgment is a two-edged sword. One close look at the judgment says that once a complaint is made under Section 154, or a complaint is made which discloses a cognizable offence, disclosure of cognizable offence calls for a very limited preliminary inquiry or a very limited piercing through the complaint, which must be made out by the investigation police officer to whom the complaint is made. That limited aspect is limited only to whether the nature of offence is cognizable or no. A reading of the complaint is necessary for the same to be determined. Unfortunately, even when the facts do not constitute a cognizable offence, people come and quote Lalitha Kumari's judgment, and they also point out its various circulars issued by the Home Ministry as well as by the respective state ministries on this aspect. After the Lalitha Kumari judgment was made out, thereafter there were 2 paragraphs included in this judgment, have been included in this judgment. And the 2 paragraphs are that in cases where there is rivalry, there is matrimony dispute, or there is civil dispute, or there is political rivalry, or there is a checkered history of litigation amongst the complainants and the accused, an FIR should be registered after preliminary inquiry. The period of preliminary inquiry initially was, in the first order, was hardly 1 week. Later on, it was increased to about 6 weeks. And following which, respective ministries have also given directions that within this framework, the preliminary inquiry in these kind of cases where rivalry, matrimonial dispute, civil dispute, family dispute, or checkered history of litigation is there, in those kind of cases, FIR need not be registered immediately. However, with respects and my humblest request to my police officer friends who know me for the number of years, not to take offense about the statement, but I'm speaking the statistics. Police being the second largest corrupt department in India after the municipal authorities. What happens is police officers are easily befriended, and without an appropriate preliminary inquiry, many a times fake cases are registered. In some cases, where actually the person who has been beaten up by a mob or by a few people, who has come to the police station and has got the FIR registered first, he is admitted into hospital. There is no reason why the police officer should ignore the fact that the person is already in hospital. He has come first, and the injuries and the first informants who have come and the witnesses who have been there have already testified that he was beaten up. Why a afterthought version should be accepted. The second last para or the third last para of the judgment of the judgment of the Supreme Court in Lalitha Kumari says that the cognizable case should be seen. That limited inquiry in case of a counterblast, of an afterthought counterblast, is necessary once an FIR is registered on a victim's complaint, that after which a counterblast sometimes is made and the police officer simply ignores the aspect. This kind of an FIR, a counterblast FIR, which is devoid of any kind of material facts and just taken out of technicality, throws upon section 217 and section 218 of the Indian Penal Code on the officers of the police. It is not FIR then. Then it becomes a fake reporting. Lalitha Kumari's judgment does not say that a fake FIR should be registered. That limited aspect of inquiry always remains with the police officer, whether such an incident has actually occurred or is it not occurred, because of an FIR disclosed first. It shows that the inquiry was there, and if that FIR is registered, how can a counterblast? I'm not saying a case where somebody has murdered his wife and has come and taken an FIR first that she was found in a dead body state, and then after a few days it was found that no, something else had happened. Those categories are different. I'm talking about instantaneous FIRs which are registered for the asking. Those are counterblast FIRs. These kind of counterblast, a counter case is different and a counterblast is different. A counter case may be a case where a case was afterwards taken. It was known that the first FIR which was registered was false and the second FIR had merits. But a counterblast, an instantaneous response where all the witnesses have shown that actually an incident X has occurred and no incident as Y has occurred, such a kind of a counterblast is what something should be discouraged by the police and discouraged by the society, and the police officers in the higher authorities should take disciplinary action on the lower authority officers who take these kind of FIRs. Number of such FIRs are there. Even in my case, one FIR was taken under Scheduled Caste Scheduled Tribe Act. Later on, the High Court has called it a counterblast FIR. In a case of one Mr. Jai Singh at Andheri, they were partying and all of a sudden a problem broke out and his brother was beaten up. Severely, he was in hospital. He was in half-dead injury state. A look at the brother would state that he was not in any position to hit the other side. The timings, the diary entries and the police diary entries also call for a clear-cut misconduct on the part of the police officers in registering a false FIR against the victim who is actually suffering. A case of Himachal Pradesh which came to me as a matter of research which we took to the Supreme Court. A person had been applying under RTIF on the village Gram Panchayat and their misgivings. He was continuously filing complaints on the elections. And all of a sudden, he was asked to come in the police station and take back the complaints. And the moment he did not take back the complaints, they called for a particular lady in the police station and they took out an FIR under 354-509 in various provisions and even slapped him. In that case, when he complained against the police officers, no FIR is registered. These kind of FIRs are the dubious fake FIRs which are taken. Another category of fake FIRs which we have seen is in the cases of extortion. What is extortion? Extortion is a very, very ambiguous. Anything can be fitted into extortion. Extortion means asking something or somebody of a valuable security or money or something which can be converted into tangible wealth and taken care of, and monetized, or a valuable benefit can be derived from that aspect. A threat to injury can also be extortion, provided that is coupled with a threat that if X benefit is not given to him, he will be defamed or he will be put under pressure. That can be also an extortion. 384 and 385 of the Indian Penal Code. Now, these kind of FIRs again suffer from lot of ambiguity, and lot of preliminary inquiry must be must be done by the police before registering this kind of an FIR. Further, FIRs of the category of 498A, dowry harassment. Many a times it is seen that, with great respect to the feminine people, I understand that the country still has a number of feminine crimes which are occurring, and sometimes a number of them are not even reported. Now, dowry, again, after years and years of marriage, people come up with dowry cases. And in the dowry harassment cases, 498A cases, domestic violence cases, it is often seen that afterthought complaints, not only against the victim but against all the relatives, and sometimes even against the uncles and aunties, are made. And in states like Punjab, all of them are arrested. We have seen this. A number of cases have come to my note, and we have conducted an extensive research on these kind of FIRs. Similar would be the case with cases where credit card defaulters. The credit card defaulters sometimes don't pay. Madras High Court gave a very important judgment in 2012, wherein all the credit card cases in which Section 420 processes were issued were stayed by the Madras High Court. All of them done by a particular magistrate. Similar is the case with defamation cases, where magistrates issue processes sometimes only because some pleading just because a pleading says, not in the necessarily category that a defamation has occurred. There are two kinds of fake cases. One is where the police, first we'll concentrate on the police case, and then we'll come on the magisterial cases where fake cases are made and processes are issued. Now, what happens in case of monetary disputes? In case of monetary disputes, there is a sale agreement in some cases. In some cases, the parties give a verbal promise that, okay, I'm buying this property and tomorrow you may assist me. That is a verbal promise. It has got no tangibility. A sale agreement is registered. The property is already transferred to him. There is no loss occurring, despite which people come in the police station and they say that a Section 420 case has been made out. Now, these kind of FIRs, when not registered, serve the purpose of law. But when registered, unfortunately, some of these FIRs are registered. A case in Thane in Maharashtra, which I encountered about 4 years ago, a deed in which a civil decree is already issued 18 years ago, a person comes after 18 years and does a criminal case on the person even after the decree is executed. The successor is doing it. All the records are there in the favor of the person, in the favor of the accused, and the court orders are there in favor of the accused, despite which an FIR was registered. And sometimes when we come to the High Court, the High Court unfortunately says matter is under investigation, will give police time to investigate. Now, the report under Section 173(2) of the Code of Criminal Procedure is the final report. Please remember, the report under Section 173(2) of the Code of Criminal Procedure is the final report. There is nothing such as charge sheet under the Code of Criminal Procedure. The final report, if discloses a cognizable case against the accused, is known as a charge sheet. Otherwise, it is a final report which shows the conclusion of the police. A final report has to be filed within a time frame as prescribed under 167 of the Code of Criminal Procedure, and it has to be filed within a specific period of time. 167 of the Code of Criminal Procedure has to be read with 173(2) for the final report to be filed. The final report again can be delayed with the permission of the magistrate, and the police has to explain as to why a delay has occurred in the filing of the final report. If after filing of the final report, in certain cases of serious nature or where the accused have not been able to be traced, then and only in those kind of cases a 173(8), which is the supplementary final report, can be filed. That is the prerogative of the police, provided the case is of such a kind of a nature. It should not be a small kind of a trivial case wherein a final report filed and after years a police comes and tries to file a supplementary report. Then the magistrate would not allow it. Now, what are the kinds of final reports? To my knowledge, they can be categorized in 5 kind of categories. The first final report is the charge sheet. The first category. in which an accused is found guilty and the police finds evidence, it files all the witnesses' statements and all the evidences on record, and police earmarks what can be issued to the complainant and the accused and what cannot be issued and remains with the court, and it has to be examined at the time of the trial. Then is a case where in Mumbai police we call it A summary, or where evidence is insufficient. So police says evidence insufficient, A summary is being filed. Then we have B summary. B summary is where a police finds that a false case was registered, and upon investigation it is found that no such investigation no such investigation carried out till now would reveal that any case of a nature which has been shown in the first information report had occurred, and a false case or a case which was not at all cognizable and incident itself was not real, that kind of an FIR was taken. In all cases, police does not insist for prosecution of a false complainant in all B summary cases. The B summary is called by Mumbai police. In various other cities it may be called by various other names. Then we come to the category of B summary with prosecution, where a knowingly false case and a false information is given in order to harass somebody. In such cases, police asks for prosecution to be carried out on the fake complainant. And in those cases, the magistrate orders that yes, prosecution should be carried out, and after that B summary's report is accepted. The second last category is the C summary. The C summary where yes, an incident had occurred, but not a cognizable one, but an NC complaint, a non-cognizable case had occurred, and a C final report is filed. Now, the last category of cases is a case where actually a civil offense is made out. Civil disputes are there. Family disputes of divisions are there. Number of cases are pending and they have been tried to be given a criminal color. In such cases, the police files a report which says that cognizable offense under the Code of Criminal Procedure or under the Indian Penal Code is not seen and it is a civil dispute. These are the categories of reports which the police can file. Now, what happens after police files the report? Here starts the major problem. If there is a charge sheet, yes, the charge sheet begins, the trial begins, the examination of witnesses begins, production of evidences start, and the trial process starts. When there is a genuine charge sheet filed and the trial begins. Framing of charge, then examination of witnesses, then production of evidence, prosecution witnesses, various things start. Now, what happens in the other categories where specifically where B summary with prosecution and C summary is there? The magistrate has to accept the report. In a famous case in late 60s, which is known as the Abhinandan Jha's case, the citation would be seen in all the major journals. It's a Supreme Court matter. In that case, the Supreme Court held that these kind of reports have to be first accepted by the magistrate. Earlier in 70s or late 60s and early 70s, in Mumbai, the Commissioner of Police had the power to grant B summary or C summary and accept that B summary and C summary or A summary or civil case report, and that would become final. The magistrate was not given that power. Then Supreme Court, by way of various judicial rulings, said that no, the magistrate has the power. Code of Criminal Procedure is silent. Code of Criminal Procedure does not call upon the magistrate to accept any kind of report. The report is filed, and because there is this ambiguity in law, in those cases where charge sheet is not filed, these kind of reports are pending for years and years. In appropriate cases, I would show even for 10, 12 years, 13 years, 14 years, these summary reports are still pending with the magistrates. This was the thing which we took into the PIL before the Supreme Court under Article 32. And on 5th March 2021, the Supreme Court gave us liberty that all the aggrieved people can approach their forums in appropriate proceedings against such kind of things. Now, what happens to the case when a B summary or C summary is it has to be accepted by the magistrate. By way of judicial pronouncement, the High Court and the Supreme Court has made it mandatory for the magistrate to issue notice to the complainant, hear the complainant, whether there is any grievance. Even the Supreme Court, with great respects, I may say, in many aspects have failed to determine and curb this practice of false cases. Suppose a false case is filed and evidently files where a B summary with prosecution is launched. The magistrate would decide it after 4 years, 5 years, 6 years. And what if the magistrate declines to accept this B summary? Where are the evidences? Where are the witnesses? Many of them may have drifted by that time. And why should a person who has been implicated in a false case wait for so many years for getting a clean sheet until the magistrate accepts it? Why should there not be a law where there should be a cap on the magistrate's time limit, and within 3 years, if a magistrate does not decide a case which is not punishable for more than 3 years, the B summary should be deemed to be accepted. This kind of a law is necessary. And the lawmakers, I may appeal before the lawmakers that this kind of a law should come in, where C summary and B summary cases and B summary with prosecution cases, and those cases where civil adjudication reports have been filed, these reports must be decided by the magistrate expeditiously. A reason in Mumbai why magistrates, or maybe even in other cities, why magistrates don't decide the B summary, C summary cases which are pending for acceptance or for non-acceptance, is, as per one of a very senior retired Bombay High Court judge who told me, the magistrates don't get points for disposal. Every judicial officer gets some points for disposal of cases in his favor, so that his upgradation in his career is there. He doesn't get points if he accepts B summary and disposes of B summary or C summary. This is one of the reasons why magistrates don't decide it. So, for a number of years, the noose of a false FIR hangs around the neck of the false accused who is implicated in a false case. Would this be fair? In an age where we are talking about computerization, in the age where we are talking about digitalization, and what if the magistrate comes to a conclusion that no, the B summary was not proper, or C summary was not proper, or even in such cases where C summary and B summary is filed and the offense is not punishable for more than 3 years. If an offense is not punishable for more than 3 years, then by virtue of section 468 and 469 of the Code of Criminal Procedure, that complaint lapses after 3 years. Kindly read 468 and 469. An offense of a crime which is punishable for a period up to 3 years, the larger limit is 3 years, which means the crimes which are punishable up to 3 years, if not decided within 3 years, become defunct. The magistrate's court becomes ex officio. The police can't do anything, and neither the criminal law can do anything about it. And that is the right of the accused in such a case. And that 468, 469 becomes operative because the magistrate does not decide. This being the case, it is very necessary that a law should be brought in, either in the Code of Criminal Procedure or by the respective high courts under Article 227 of the Constitution, that magistrates have to compulsorily decide any final report filed under 173(2) within a period of 3 years, and if he does not decide within a period of 3 years, that report is deemed to be accepted. That will reduce the pendency of cases, and that will also give a sense of satisfaction to those people who have been implicated in false cases. Now comes to the aspect as to when a police does not register the FIR in a genuine case. In a genuine case, if police does not register a FIR, the person comes under 156 in bracket 3 of the Code of Criminal Procedure to the magistrate. Nowadays, magistrates insist that instead of 156.3, people should also go in for 154.3. And now what is 154.3? 154.3 is a complaint which is made to the Deputy Commissioner of Police, because under Section 36 of the Code of Criminal Procedure, the DCP is the final deciding executive authority over the police station. And he can give a direction that an FIR should be registered. With this argument, I may conclude about 3 or 4 things. One is, if a police officer knowingly takes a false FIR, then he should be prosecuted under 217 and 218 of the Code of Criminal Procedure, because Lalitha Kumari's judgment nowhere says that a FIR which does not disclose a cognizable case should be registered. Please read the judgment towards the end. It is very, very clearly stated, even in the second last paragraph, a cognizable case must be disclosed. So limited inquiry has to be made. Of course, in a case where a person has died, in a case where a person has died in mysterious circumstances, in a case where a person has died by way of a knife cut, a case where he has been stabbed, or a case where a dacoity has occurred, in those cases the FIR must be registered. And as per respective ministries' guidelines, in women crimes of rape, in certain crimes where women crimes are there, provided there is no rivalry, or the woman has not been used as a puppet or as a proxy for somebody else, genuine cases of feminine crimes have to be maybe registered immediately. I'm talking about genuine cases, not about afterthought and belated cases. Then those cases where a FIR was taken because of various factors, and it seems that after investigation and proper investigation, police has filed a B summary or a B summary with prosecution. Then in those cases, the magistrate must decide the case within a proper time frame set. And in that time frame, he must take a decision as to whether the B summary should be accepted. He cannot enjoy a time infinity in which everything gets wiped off, and both the accused who has been falsely implicated may be suffering, and the complainant in a genuine case also may be suffering, because he has a right to voice out. C summary cases also, if there's a non-cognizable case, most of the non-cognizable cases expire after 3 years of the offense, because in most of the non-cognizable cases the offense is punishable up to 3 years. And after a B summary has been granted, or a B summary has been accepted by the magistrate, the complainant must have a compulsory right to prosecute the falsely implicated accused must have a compulsory right to prosecute the fake complainant then and there itself. That report itself should be used as an information to the magistrate under section 190 of the Code of Criminal Procedure, and an amendment must be carried out. Whether police ask for prosecution or no, the fake complainant should be prosecuted by the magistrate himself upon acceptance of a B summary. If a B summary is accepted, you don't require any permission for prosecution. Immediately there should be a FIR registered in the police station, or the magistrate should be issuing process of trial to such kind of a fake complainant. Then and only then will situation improve. Now coming to the case where such kind of cases are going to High Court under section 482 of the Code of Criminal Procedure, those are the quashing powers. Quashing powers in High Court are often used with Article 226 of the Constitution of India. Though quashing can be made under 482 of the Code of Criminal Procedure individually and by itself by way of a criminal application. But in some cases where investigation is lacking, people use Article 226 of the Constitution of India with 482 of the Code of Criminal Procedure. With great respects to High Court as well as the Supreme Court, in many befitting cases, specifically in cases of matrimonial nature, fake feminine complaints where the female employee has been disgruntled with the employer, some kind of a complaint is made. I'm not talking about all feminine complaints. There are several feminine complaints which are genuine also. I'm talking about the fake ones. In such kind of cases where the data itself, prima facie itself, it can be seen that the crime did not occur only, why should such a case be left at the mercy of the magistrate? I understand that in quashing, in 482 and 226, evidence cannot be gone into by the High Court. But when the evidence itself is so staring, so naked and so clear that a fake case has occurred, why should the High Court stay behind in quashing such kind of cases? These kind of cases were described by the Supreme Court in Bhajan Lal's case And there were 7 or 8 categories where these kind of cases were seen. And one of the categories which have been emphasized by the Supreme Court is when there is an element of vexatious nature or element of rivalry, then too the High Court can quash it. In the case of Bhajanlal versus State of Haryana, this thing was taken up. Further, another aspect is the investigation officer's duty. Right from the late 1950s cases of H. N. Risbad versus State, a Supreme Court decided matter, then Bhagwant Singh's case, and then various other matters, even in Lalitha Kumari it is discussed. The role of the investigation officer. The investigation officer's role can be penetrated under Article 226 of the Constitution. It can also be penetrated under 482 of the Code of Criminal Procedure if the officer has not done his duty properly. I don't see any reason why the investigation officer should not be pulled up for doing certain things and not doing certain things. I am not asking the Honorable High Court and the Supreme Court to become a police officer itself. But when in patent cases where it is seen that some things which were supposed to be done were not done, then in those appropriate cases, the officer must be pulled up. In befitting cases where FIRs ought to be registered, I will tell you about those cases where ought to be registered and police officers have not registered. And there they conveniently say we will not follow Lalitha Kumari. Because there they say that Lalitha Kumari is not mandatory. But in cases where fake cases have to be registered, Lalitha Kumari becomes mandatory. This kind of a role played by the police in these days, with respects. I'm not antagonizing the police, but I'm talking about those officers who bring bad name to the police department. Of course, there are good officers, very, very good officers who have brought a lot of fame to the department. Many police officers who go out of the way to give justice to the department, they even go against their own brethren. It is not that police is comprising only of bad officers. Police comprises of very good officers also, due to which the police machinery is functioning. Now, these kind of investigation officers who do not bring the preliminary inquiry to a proper conclusion, and who do not conclude the preliminary inquiry in many cases where there is an evident case. For example, there is a case of one flat being sold out to 3 people. Can one flat be sold out to 3 people? And even if it has been sold out to 3 people or 4 people by way of registered agreements, what happens to the first registered agreement? So in such cases where evidently a crime has occurred, if a police officer files a report, it is civil, then again the police officer should be pulled up under 217 and 218 of the Code of Criminal Procedure, framing a false report. A false report cannot be filed in a case which is evidently a criminal case. There may be various examples where it is evident that police doesn't file or doesn't make an FIR taking advantage of Lalitha Kumari's exceptions, and sometimes files FIRs just because Lalitha Kumari's judgment is there. In a very, very sad case of suicide at Chembur in Mumbai, the police kept the FIR pending for 1 year. What have they done? They have filed an accidental report. How can suicide become accidental report? Please tell me. In Chembur in 2020 or 2019, a case occurred. And in that case, a suicide was done. People in the area were aware that the girl was tortured. After 7, 8 years or 9 years, a person can commit suicide. For dowry and 498A, there is a aspect of 7 years of marriage which has to be considered, not for suicide. In such a case also, police kept the matter for FIR pending for 1 year, and Honorable Justice Shinde of the Bombay High Court in Division Bench asked the police to take the affidavit of the brother of the victim and asked and requested the Chief Public Prosecutor to have the FIR filed. So this kind of use or misuse by the police, this needs to be controlled. There should be a law which has to be made that the magistrate should decide the B summary, C summaries very fast. A time limit should be set in. FIRs, a limited inquiry is very necessary to find out whether an incident has occurred or not occurred at all. And if at all a police officer is forced to take a FIR which he knows to be false, he should file a report under 157 that the case cannot be investigated. And if he files a B summary or C summary, magistrate should decide it in a period of time. The ambit of the High Court of not going into evidence has to be altered. some bit of evidence the High Court has to see to ascertain as to whether the crime had actually taken place or it is a evidently vexatious case. Bhajan Lal's decision of the Supreme Court supplied, and there should be a law which should be very strict on the police officers' duties in such cases. I am again saying, with due respects to those officers who perform well, who are very good and must be elevated. It is not that police is comprising of only bad officers. There are very good officers also. But then the misuse is more, the use is less. I hope and trust I don't hurt anybody's feelings and have presented my views in a very unbiased way. Jai Hind, Jai Bharat.